Well, joining us now in studio to discuss what constitute public interest in the arguments for and against the reinstatement of the two NPA advocates is the chairperson of the General Council of the Bar of South Africa, Advocate Vuyani Ngalwana. A very good evening to you and thank you so much for joining us.
Good evening, sis. Just one correction. I'm a former chairperson of the GCB. My tenure came to an end on the 14th, Saturday.
Wow.
There is now a new chairperson. His name is Wat Pringle, SC. He's currently in Vietnam. And I'm not speaking on behalf of the GCB. I'm here to speak
in your personal capacity,
my own views, and I'm not speaking on behalf of Advocates for Transformation either. So let's.
Thank you very much for that clarification. And to our viewers at home, our phone lines will be open, so you can give us a call on 011-542-1046 just to share your views on this matter. Advocate, you are still an advocate, so I'll just address you as advocate, but thank you for clarifying your status there. Just talk to us about some of the arguments, both for and against the advocates being struck off the bar.
Well, look, there is a rule of the bar and of the GCB that a member of the bar cannot speak publicly about the merits of a matter that is before the court. So I can't take liberties to do that. But what I can talk to you about is the reasons that I certainly have advanced for why the GCB should not, in all conscience, bring an application for leave to appeal to the Constitutional Court. And I understand these reasons are shared, some of them are shared by the Advocates for Transformation. There were essentially about 5. Let me see if I remember all of them. The first was the GCB plays the role of what lawyers call a custos morem. It's Latin for literally the custodian of the morals of advocates. And this covers all advocates in the country. It's not just advocates who are members of the bar or the constituent bars of the GCB. Even persons who are not in practice but are on the role of advocates, are admitted as advocates in terms of the Admission of Advocates Act. Because a custos morum is a role where you bring the facts that you consider may constitute grounds for either an application to have an advocate struck from the role because he's not fit and proper in terms of Section 7 of the Admission of Advocates Act, or to have that person suspended. The various constituent bars have certain powers in terms of their constitution and their rules of ethics. They can suspend members, they can do all kinds of things, but what they cannot do is by themselves to strike off advocates, right, or suspend them as advocates. They can suspend them as members of the bar, but they cannot suspend them as advocates. Only the High Court can do that. So what a bar does is put together facts in the form of an affidavit, bring an application to the High Court with all those facts. Then the judge or the High Court, whether it's a full bench or a one-judge bench, will consider those facts and see whether that makes out a case for a striking off or, alternatively, a suspension. That's what a custos morum does. Obviously, it doesn't just place facts. It also relates the laws that are applicable. So it applies those facts to the law, and then the judge makes a decision. What happened in this case, and I'm not talking merits here, I'm just stating the facts as happened, which is all in the public domain. The High Court considered those facts and the law and found that a proper case had been made out for Advocate Jiba and Advocate Mkhwebi to be struck from the role. Now, in my view, that is where the role of the GCB and the bar ends, as would the role of, for example, an amicus curiae. Now, you will have heard of amicus curiae. There are lots of them running around in cases of constitutional import. An amicus curiae is similar to a custos morum, because what they do is they bring facts and the law in order to assist the court so that the court can reach an appropriate decision on the basis of the facts and the law. Now, once a court has made a decision on the basis of those facts and the other party brings an application for leave to appeal, this is the distinction that has to be made. The other party brings an application for leave to appeal. The role of the custos morum still continues. to place those facts before the appeal court, right? But once the appeal court reverses the decision or finds against the custos morum, it is not the role of the custos morum or amicus curiae to then bring an application for leave to appeal to a higher court, because once it does that, it's now no longer a custos morum. It is a litigant, and the GCB is not a litigant in matters of this kind, nor, or in the same way as a friend of the court. An amicus curiae is not a normal litigant. It's there to assist the court. It's not pursuing one outcome or the other. It's there to assist the court. That's the first reason, which is the main reason. There are numerous other reasons, such as, for example, in less than 4 months' time, the Legal Practice Act provides that by the 1st of November, there will be something called a Legal Practice Council. There'll be various provincial councils and then the National Practice Council. That council is going to take over the role that is currently played by the various constituent bars. In other words, the custos morum rule is now going to repose in the Legal Practice Council. Now, the Legal Practice Council may very well decide that it is in the interest of justice to bring an application to have these two advocates struck off the roll. There is absolutely no urgency for the GCB to bring such an application, especially in what I consider to be such a politically fraught environment, because you'll recall that this case really emanates from a political party wanting to get rid of these two advocates. And that, in my view, is the fons et origo of this whole thing. So for the GCB or any constituent bars to step in and seek to achieve a result that a political party seeks to achieve, by reason, I don't know, there was a prosecutor who's now a member, I forget her name. Prosecutor used to work at the NPA, and I don't know how her membership of the NPA ended. And since then, she has been very vocal in opposition to Advocate Jiba and Mkhwebi and wanted to have them fired and so on. So for the GCB to be seen to be playing, or rather acting as a conduit.
If I'm not mistaken.
Is it, sorry, what's her name?
Glenys Breitenbach?
Breitenbach, yeah, that rings a bell. I don't know her. So that's the second reason. That role will now be played by the Legal Practice Council to do that. And they can go directly to the Constitutional Court in terms, I think it's Rule 17 or 18. Direct access to the Constitutional Court, and all they have to establish is that this is in the interest of justice. And of course, because this matter will have been aired in all the lower courts, there would be no need for them to bring an application for leave to appeal to the Constitutional Court. In as much as the LPC would not have been a party to the proceedings in the lower court in any event, they wouldn't be able to do that. But nothing stops them from going directly to the Constitutional Court. Let me punctuate this by saying, one of the points I raised at the AGM of the GCB was this, and I continue to raise it. If the GCB had not taken the decision to bring an application for leave to appeal to the Constitutional Court, I could guarantee it, without any shadow of doubt, that one or other or all the NPOs, the non-profit organizations, would have stepped in. Chances are the Democratic Alliance would have stepped in and brought an application of that kind direct to the Constitutional Court in the public interest under Section 38 of the Constitution, and they would have argued that this is in the public interest, the Constitutional Court must look into this. So had the GCB not made the decision to bring this application, it wouldn't have been the GCB washing its hand off the matter, because there would have been other parties who would most certainly have brought that application. Third, until today, I had heard that the president was considering the fitness for office of at least Advocate Jiba. I don't know about the other advocate. Today I hear that the President Zuma's, sorry, that's a different point. So the president was considering this thing. Now, he said reportedly that because the matter of Ms. Jiba's fitness for office in the NPA is still currently before the courts, he cannot do anything about the inquiry because he would be seen as interfering with the processes of the court. By the GCB taking the matter to the Constitutional Court, in my view, it's impeding the president from exercising his presidential powers in relation to the NPA advocate. Or for those of us, well, I don't include myself in that number, but those in the public who are cynical, they would argue that, well, the president is probably using this as an excuse for not doing anything about a matter on which he should be doing something. Fourthly, President Zuma in December of 2017, right, was found by the High Court in Pretoria, I think it was, that his failure to do anything in relation to Advocate Jiba's, I would say, excoriation by a number of judges as regards the manner in which she was doing her job as a prosecutor was unlawful and irrational. And so he would have been compelled to do something about it. He brought an application for leave to appeal against that judgment. But that application for leave to appeal, or that appeal, was then placed on ice. Why? Because the GCB's matter to have her struck off the roll was still before the court. So it was placed on ice until this matter had been resolved. So with the GCB continuing to now act not as custos morum, but as a litigant, it is actually delaying the bringing to justice of the former president, right? Mm-hmm. So those are the reasons that I can recall for now.
And would you say that there are some racial tensions? I mean, I know that you've mentioned a bit of a political influence in some areas, but are there also racial tensions at work in the legal fraternity?
Look, I've been accused of accusing the GCB of being racist. I said nothing of the kind, and I don't hold the view that the people who voted in favor of the GCB bringing the application are racists. That's a serious accusation. There is a difference. Mm-hmm. And I think maybe for the benefit of your viewers and maybe some lawyers as well, there is a vast difference between racism and racial bias. They're not the same thing. What I find, and this is not just about this matter, this is about discipline at the bar in general, at the various constituent bars. I have been a chairperson of the Ethics Committee, which I would loosely call the Ethics Committee. It's called the Professional and Fees Committee in Johannesburg. I have served on that professional committee also as an ordinary member. I've been a member of the Bar Council in Johannesburg, and I have had matters coming to us dealing with the disciplining of members. I have been a chairperson of the GCB. I have had to deal with matters of appeal from constituent bars dealing with discipline of members. I have seen a distinct pattern where black advocates are particularly targeted in these matters. And I'm not just talking about striking off matters now, I'm talking in general about the disciplining of advocates, right? So one cannot ignore it. I cannot ignore that pattern and simply recoil in my shell when people accuse me of accusing others of racism. I will mention the fact, and I repeat, there is a distinct pattern. And I do have the evidence. I mean, I'm not going to say it in an open forum like this, but if, for example, the chairperson of the GCB would like an open debate, and I've invited him, that we have an open debate on transformation and disciplining of members at the bar. If he's open to that, and he says, well, we can mention cases, I'm more than willing to do that, right? So to answer your question in not a roundabout way.
In a nutshell.
In a nutshell, I have observed a racial bias in matters of discipline. But I cannot say that that is an indication of racism at the bar. Big difference. And those are the issues, those racial biases are the issues that, in my view, need to be addressed. And I have called on the various constituent bars when I was sitting as a chairperson of the GCB to give me the statistics of matters in the last 5 years or 10 years, I can't remember what it was, the number of years, in matters of discipline. Because what I want, and this had nothing to do with this case, the judgment hadn't been given here, so it didn't feature at all. I wanted to see how badly the situation is. I know it is bad because I do have examples, but I wanted to see examples from other constituent bars because chances are the picture in Johannesburg is reflected in the various other constituent bars. But evidence of what happens in Johannesburg I do have, And I didn't get an answer from the various constituent bars. I think I had one, which was very dismissive, saying we don't keep those kinds of statistics on, and I didn't even ask them to give me a racial breakdown of the disciplinary matters. I hear that the National Forum asked for the same information. Perhaps one can get that information through the National Forum, and then we can do a proper assessment.
Well, Advocate, thank you very much for joining us in studio. It's been very enlightening for our viewers, I'm sure, just to hear your thoughts as well. And just a reminder that the former chairperson of the General Council of the Bar was speaking in his personal capacity and not representing any organization. It is time now for a short break. We're back at the top of the hour with more news and updates, so do stay with us.